Good morning to members of the media, and thank you for coming. In the invitation I sent you, I said that I would discuss the manner of the government implementing its recent decision to deport Africans via means of a chartered plane to take them back home at a cost of approximately $2.5 million. And I would also discuss with you the announcement of the Prime Minister that government was giving $55 million to churches for the celebration of Christmas, and that she stated publicly that the monies were not government monies. The necessary implication of that statement of the Prime Minister was that the monies were coming from a private source and not from the government. The handing out of money, vouchers, to some of the invitees at the Christmas lunch hosted by the Prime Minister for members of the media was the third issue. The Prime Minister stated that after this was made public, that anyone who got vouchers were free to return them. These three issues have serious implications for the use of private funds for public purposes and the use of state resources for party political purposes. The fourth issue was that the people of the Caribbean must have a say in the replacement of the Privy Council by the Caribbean Court of Justice as the final court of appeal. In respect of the fourth issue, this morning I got a judgment from the Privy Council which is very important and which I will also concentrate upon. That judgment had to deal with a former Prime Minister who has been Prime Minister of St. Vincent and the Grenadines for 19 successive years, and he was not able to get justice locally, and he had to apply to the Privy Council to get justice. As a citizen of Trinidad and Tobago, in dealing with the first three issues, I must say that, having regard to recent events, I am most concerned to see that the Prime Minister of Trinidad and Tobago, dressed up like Santa Claus, in Santa Claus outfit, going all over the country, distributing toys, when the murder rate of the country is 397, and there are so many other serious issues adversely affecting the people of Trinidad and Tobago. The Prime Minister is using the national helicopters, which are intended to be used in the fight against crime and for national security issues, to travel with an entourage all over the country to distribute toys. That really is a function of a junior officer in the office of the Prime Minister or the relevant ministry. The Prime Minister instead should be concerned with the crime problem in Trinidad and Tobago and should devote her time to fixing the crime problem instead of distributing these toys. While citizens are murdered and criminals are not caught or prosecuted, and there is anarchy and breakdown of law and order in this country, the Prime Minister plays Santa Claus. I have a major problem with that, because I think this show is going too far. And I think the people of Trinidad and Tobago should become very serious about how government should operate in Trinidad and Tobago. The Prime Minister is demonstrating that there is no serious appreciation by her of the functions and duties of Prime Minister. She should be dealing with serious governance issues facing the country. Right now, this country is facing a serious threat with the falling price of oil. The Prime Minister promised in her manifesto that one of the priorities of the government would have been diversifying the economy. That has not happened, and the falling price of oil and gas is likely to occur for another year. Whilst all this is happening, the Prime Minister is reckless in spending monies. I think the time has come for us to talk frankly about these issues. and for the people of Trinidad and Tobago to understand that unless these matters are considered seriously by them, unless the Prime Minister is condemned and made to account, there would be no future for the young generation of Trinidad and Tobago. While some of the toys that the Prime Minister is distributing, she is distributing these toys, I must say that it is important for us to know whether these toys were donated by a private source or whether the toys are being financed by the government. She has a duty to disclose to the population, if they're donated, who donated them. If these toys are being donated by contractors who have got contracts from the government in breach of the procurement procedures, then serious questions arise as to conflict of interest between the government and these private contractors. In any event, if these toys are being donated by private contractors, the population ought to know, because there's a procedure for government to get gifts from private individuals. There are rules and procedure to be followed. And therefore, the Prime Minister cannot be suspected of using state facilities and private resources to promote party political issues. And therefore, I think it is very important for these questions to be asked of the Prime Minister, and it's very important for the Prime Minister to answer these questions. These same questions arise in respect of the government giving $55 million to the churches. If the Prime Minister is saying, as she is saying, that the monies are not government monies, then if they are not government monies, the Prime Minister must disclose the private source of these monies. Are contractors who are benefiting from these illegal contracts which the government awarded, or who are benefiting from the award of contracts giving this $55 million? The answer to these questions are important, because it must be known not only whether there are conflicts of interest, but whether there are possible breaches of the integrity laws of Trinidad and Tobago, and whether the monies are the proceeds of crime, including drugs, money laundering, and other criminal offenses. The recent event in which there was the donation of money vouchers to certain members of the media at the Prime Minister's Christmas lunch also makes some of these questions very relevant. The public must know whether taxpayers' monies were used to give the gifts to some members of the media, and again, if so, whether the financial regulations for the disbursements of these public funds were followed. If taxpayers' monies were given to some members of the media, the Prime Minister must tell the public why some members of the media were given money and other members of the media were not given the same treatment. The Constitution of Trinidad and Tobago mandates the Prime Minister to treat all equally. If taxpayers' monies were not given, and the monies given to some members of the media came from a private source, the Prime Minister must state the source the monies came from. Did those contractors finance the gifts of some members of the media? Prime Ministers or Ministers of Government are not permitted by the law to use state resources for party political purposes. And if there are financial regulations and procedures in place for monies which are being donated by private enterprise or private sources to government are not followed, the Prime Minister must not use those funds for public purposes. The use of state resources for electioneering purposes is against the law. The Indian law enforcement authorities and the court system in India demonstrated in one of the general elections in India, when Prime Minister Indira Gandhi was accused of using state resources for party political purposes, that it was serious about those laws and those offenses. The High Court of Allahabad in India in 1975 convicted Indira Gandhi for using those funds for electioneering purposes, misconduct in public office, and banned her from politics for 6 years. The Prime Minister, in response, declared a state of emergency and imprisoned thousands of political opponents and restricted personal freedoms in the country. In the next general elections in India, Prime Minister Indira Gandhi and her party was swept from office. I mention these facts to tell you and to tell the country that what we are seeing must be answered, because if the state resources are being used for the promotion of party political purposes with the use of private funds or monies from private sources, serious questions arise as to whether the law in Trinidad and Tobago is being broken. I want to touch a little on the deportation issue. In respect of the 15 Africans who on Saturday the 6th of December 2014 were deported, I wish to make it clear that I am not contending that illegal immigrants should not be deported, or I am not denying the right of the government to deport illegal immigrants. The government clearly has such a right and a duty. The manner, however, in which this deportation took place must be condemned, because the government, before the immigrants exercised their rights to go to court, and before the courts made a decision in their applications to the court, chartered a plane and had that plane waiting to take them to Africa. During the Saturday night, for approximately 12 hours, the High Court and the Court of Appeal heard their applications until about 6 o'clock in the morning, and they were deported on Sunday after their applications were dismissed. The government did not give adequate notice to the immigrants or their families for them to properly participate in their applications. There was the rationing of due process of law by the government, in that the immigrants were entitled to the respect of their private and family life and the full due process of law to have their applications heard and determined. The Constitution of Trinidad and Tobago guaranteed to every individual respect for that individual's private and family life. It does not only guarantee it to a citizen, every individual who is in Trinidad and Tobago. These Africans were entitled to have that right enjoyed, which meant that there should be adequate notice and their family ought to have been notified, and there should be full due process of law. Due process of law in this country was compromised when the government did this emergency operation. There was no reason why the government could not have given adequate notice to the immigrants to allow the court system to determine the matter in the normal way, so that their families would have adequate time to participate in the proceedings. After the proceedings were determined, any such charter could have taken place. The question which any reasonable citizen would ask is why this emergency hearing and procedure through the night with a chartered plane waiting to be used for the deportation of those Africans, but they were not and are not being used and done for persons of other ethnic backgrounds in Trinidad and Tobago. This is a serious issue. Some of the people and some of the persons in public life who are afraid to talk about this issue, I want you to know this is a serious issue. This is an issue in which the government is showing that it was going to operate a certain way for a particular ethnic group, but they are operating another way for other ethnic groups. This, in my view, is gross inequality of treatment, and if there is to be a commission of inquiry, there should be a commission of inquiry into this matter. I want to devote the rest of my time to the Privy Council decision which was handed down this morning. The Privy Council, in a unanimous decision of 5 judges today, decided that a former Justice of Appeal, Ephraim Georges, who was the one-man commission of inquiry appointed by Prime Minister Dr. Ralph Gonsalves in 2003 to investigate Sir James Mitchell's role as Prime Minister and Minister of Finance in the Otley Hall project in St. Vincent, must not sit further as Commissioner of that inquiry. It held that an interim report prepared by the Commissioner showed evidence that he was guilty of apparent bias against Sir James. The Privy Council decided that the Commissioner cannot approach the remainder of the inquiry with an open mind and would not be able to conduct an impartial inquiry. The Privy Council ordered the Commissioner to take no further part in the commission. The Otley Hall project involved the construction of a marina and shipyard in St. Vincent. Prime Minister Gonsalves alleged that the project failed and it was fraudulent because monies were diverted from the project for the benefit of some politicians and some public officials who were in office at that time. The terms of commission of the inquiry made Sir James Mitchell a subject of the inquiry. Sir James Mitchell was Prime Minister for 19 successive years. The Commissioner, upon commencing the inquiry, requested Sir James to be interviewed by investigators who were assisting him. When Sir James, through his lawyer, wrote to the Commissioner to get particulars of the matters which were the subject of the interview, so that Sir James would have been able to adequately prepare for the interview, the Commissioner did not respond. The Commission of Inquiry proceeded to take evidence in the absence of Sir James or his lawyer. The Commission of Inquiry Act of St. Vincent had a provision for Sir James to obtain from the government payment of his reasonable legal costs for retaining lawyers to appear before the Commission of Inquiry. The Prime Minister, Mr. Gonsalves, and his government, in the absence of the opposition party, repealed that law, thereby denying Sir James the right to have this payment. Unknowing to Sir James, the Commissioner prepared an interim report based on the evidence taken in the absence of Sir James. The Commissioner sent that interim report to the DPP and to the Governor-General. This report was sent to them on the eve of the general elections, which were held in December 2005. In that report, the Commissioner made conclusionary finding against the former Prime Minister. The finding included that he was guilty of serious misconduct. The Commissioner did not give to Sir James an opportunity to make representations to him in respect of his proposed findings in the interim report. The contents of the report, however, were used by the Prime Minister Gonsalves during an election campaign of 2005 in order to promote him and his party and to condemn the opposition party. After the general elections, which the Prime Minister Gonsalves won, Sir James commenced an application for judicial review against the Commissioner. He lost in the High Court, he lost in the Court of Appeal. The local courts held that although in the interim report the Commissioner expressed strong language against Sir James, that there was no unfairness in the Commissioner continuing that inquiry. On the other hand, the Privy Council found that based on the findings made by the Court of Appeal, it was not possible for the Commissioner to conduct a fair and impartial inquiry. This decision shows that Sir James Mitchell had the benefit of an external court to give him justice. The trend in the world today is for courts and tribunals to deliver justice to citizens across the world by the establishment of transnational courts. For example, several states of Europe have the European Commission of Human Rights and the European Court of Justice. Similarly, several states of the United States of America have the United States as the final Court of Appeal, have the United States Supreme Court as the final Court of Appeal. In addition to these transitional courts, there's a trend of the development of common legal values and principles. These are being approved by courts to give justice on constitutional law, public law, and private law. In the world today, there's the internationalization of legal principles and values, and these are applied by these transnational courts in the final determination of the rights of citizens. The Caribbean region is fortunate to have the benefit of the infusion of the decisions of the Judicial Committee of the Privy Council and its jurisprudence in the development of law. Any examination of decided cases of the Privy Council in respect of appeals from the Caribbean countries over the years would show that the people of the Caribbean have benefited and continue to benefit from landmark decisions given in relation to the enjoyment of human and fundamental rights. The reports of the Caribbean would show that in many politically sensitive matters, the aggrieved citizens are able to get justice before the Judicial Committee of the Privy Council. The premature abolition of appeals to the Privy Council can adversely affect the enjoyment of rights of the people of the Caribbean. The Right Honourable Dr. Eric Williams, as Prime Minister of Trinidad and Tobago, when the country became a republic, in answer to critics for a republic constitution to maintain final appeals to the Privy Council, defended the government's position by saying that there was nothing wrong for a small country like Trinidad and Tobago to have justice determined by an external court. He said that we live in a very small society and that it was important for persons not only to get justice, but for justice to appear to be done in a society. He saw nothing inconsistent with maintaining appeals to the Privy Council and the sovereignty of the people of Trinidad and Tobago. In fairness to Dr. Eric Williams, he had the political foresight to predict the present trend of having transnational courts deliver justice and the internationalization of legal principles and values. This decision of the Privy Council in the Sir James Mitchell matter fortifies the argument, in my view, for the maintenance of appeals to the Privy Council, and that if governments wish to accede to the Caribbean Court of Justice as the final court of appeal, it is necessary for them to give to the people a say in that decision. They must hold a referendum on the issue so that the people of the region would be able to examine the judgments given in the local courts as against the judgments given by the Privy Council, together with other arguments for and against the retention of the Privy Council so that the people can make an informed decision. The Supreme Courts of the Caribbean are the pipelines through which citizens get justice. These Supreme Courts are the guardians of the constitutions of the rights of the citizens of the various countries. If the pipelines for justice in these countries are blocked or obstructed in any way, the citizens would not be able to get justice. Justice would be rationed. In any society in which justice is rationed, it poses a serious threat to the enjoyment of the rule of law and the enjoyment of human and fundamental rights. Sir James Mitchell case is only one of the cases that I fought through the local court system. In that case, I fought it through the local court system in the High Court, the Court of Appeal, and then with the assistance of English lawyers, we went to the Privy Council. We argued that case in November, and we got a judgment in December. In Trinidad and Tobago, quite recently, we had the case of Guyadine. Guyadine was a case in which a bar owner had his bar operating. He occupied the lands, and it was the established law in Trinidad and Tobago that since he was in possession of these lands, he was entitled to remain on the lands. He lost in the High Court, he lost in the Court of Appeal, and the Privy Council reversed the High Court and the Court of Appeal. There was a recent case also of Beacon and Insurance Limited, in which we went through the court system. We won in the High Court. On a question of fact, it was reversed in the Court of Appeal. And we won in the Privy Council. If it were not for the Privy Council, this man would have lost his claim, against an insurance company. He has lost everything he had in a fire. And because of that decision in the Privy Council, he was able to get his judgment. I am saying these things in order for the people of Trinidad and Tobago to understand that justice is an important issue. It affects the lives of everyone in Trinidad and Tobago. And if the system of justice is going to be changed by taking away an institution, politicians must be able to give the people an opportunity to participate in that decision. Thank you very much.
Wouldn't the Caribbean Court of Justice perform the same function as the Privy Council?
The judges who go to the Caribbean Court of Justice are the same judges and based on the same system that we have in the Caribbean. In most of the Caribbean countries, the perception of the members of the public and from the decided cases is that the national justice systems of these countries have to be fixed before you can think of appeals to the Privy Council. Let me give you an example. Our Constitution expressly states that if you are arrested or detained by a police, you're entitled to have a lawyer, to communicate with a lawyer. The High Court and the Court of Appeal of Trinidad and Tobago years ago held that although the Constitution said so, the police was not part of the state. So this case had to go to London, to the Privy Council, and the Privy Council decided that when you're arrested, the police is part of the state and you're entitled to have a lawyer. I could give you numerous cases on constitutional law and public law in which, in very politically sensitive matters in the Caribbean, the aggrieved individual loses but succeeds in the Privy Council. Whatever the reason may be, I think one has to be able to look at this, and the people are entitled to look at it. I am not saying that we do not have competence in the Caribbean, competent judges. There are. But when you look at the cases decided in the Caribbean, and when you look at the cases decided in England in the Privy Council, throughout the Caribbean, something has gone wrong with our system which has not been fixed. And until we fix that system, I think we have to maintain appeals to the Privy Council. And there is nothing inconsistent with Trinidad and Tobago becoming a republic country or an independent country or sovereignty in having appeals to the Privy Council. And I'm sorry if some of you came late and you didn't get the whole thing, but I think you got most of it.
Yeah. Actually, we went late because we went to the wrong building.
Again?
Yeah. Park up everything and we'll come out with equipment and put it back in the car.
Which building you went in?
The usual Dalton.
You went to Dalton?
Well, yeah.
But you didn't come here since I moved back here?
Yes,
No,
he
you
did.
was moving in last time you had your last press conference.
He came here
You
already.
came here and then you went back there.
Oh, I see.
So we had a little mix up there. A little bit late. After fighting Papa and offload